Welcome to another episode of Ask the Lawyer. This is the podcast where we tackle your legal questions no matter how big, small, or complicated they might be. As we always start, I am Evan Schwartz, the founder of the law firm Schwartz, Conroy, and Hack. I'm Matt Conroy, Evan's partner. And we always have to start with our little disclaimer, which I am going to read for you now. The information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Watching this podcast does not create an attorney-client relationship with any of the attorneys featured or the firm. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. And with that, we're going to get right to our questions.
Is it normal for insurance companies to push back on claims?
Matt? Generally speaking, probably yes. I think typically, there might be a threshold question of whether whether the claim is covered. Once there's a determination that there's coverage for the loss, you're into sort of the adjusting the loss phase. And, it depends if we're talking about a flood in somebody's basement. If you're, it's different in different circumstances, but typically in the process of adjusting a claim, insurance companies try to push back a little bit. And with auto, when they're trying to repair a vehicle, they're going to push you to use their people where they have sort of set schedules on repair costs and things like this. With homeowners, with flood and fire, typically they work almost with the restoration people to sort of stop the damage. But when it comes to the fix and the repair and how much they're going to, give you for certain loss items, things like that, having a public adjuster sometimes is good because, they're not, and different carriers are different, obviously, but I think that's where you see some pushback on homeowners claims.
I would say it's not unusual for an insurance company to push back on a claim. But they go through their process. And like Matt said, certain carriers are going to be harder on certain things. Certain of them have a period in their life cycle where there's areas of coverage where they're pushing back. Sometimes they're in a period where they're having financial difficulties and they step up their claim scrutiny. It depends, but it's not unusual. So we're in business because of that.
Yeah.
That insurance companies push back on claims. They deny claims. They limit the amount they're going to pay on claims. So if it happens, while it might be frustrating and it might be aggravating, it's not unusual.
Yeah, but it's probably important for people or insureds to be a little bit sensitive to the fact, to the sense of like, is my carrier pushing back on this? And when you rely on their adjusters coming out and sort of allocating money for certain components of loss or what have you, when you feel like they're shortchanging you on something, it's probably important to be a little bit proactive on that. And public adjusters are good for certain types of losses. Homeowners, great example. Things like when you're getting sued, and it's professional lines or malpractice, this type of thing. I mean, they're going to cover it if you're getting a reservation of rights letter where they're going to undertake the defense, but they push back on whether or not they're going to indemnify the claim. That kind of pushback is probably important to consult with a lawyer at some level.
Agreed.
But in your typical homeowner's loss, as long as they're working with your people to remediate the loss and to start fixing things,
Or working with you.
it's not necessary in a lot of these cases that people have lawyers, but when you really feel like they're either setting you up or pushing hard, you start with a public adjuster, and eventually maybe you talk to a lawyer.
Or you just start on your own if you've documented properly and you have good professionals to give you the proper estimates, assuming we're talking about a property damage claim. But yes, it's not unusual. And it doesn't mean you need to run out and go hire an attorney or even hire a public adjuster, depending on the complexity if it's a property damage loss.
We have it's sort of on topic, but we've had cases over the years where people essentially the carrier covered a little bit of the claims, but not all the claims, or covered a lot of the damage in the remediation, but not all of it. And then, with no real guidance, the client or the insured went out and did the repairs either themselves or with relatives or with friends where, there was no invoicing, there's no checks, there's very little documentation. You can see the work was done, but difficult to sort of quantify with paper evidence, or with financial records. And, those people would have benefited greatly from a consult with a lawyer before they sort of spent the money or
Or a
spent
public
their
adjuster.
or a public adjuster.
Yep.
So, before if you feel you're getting pushed back on and your response is to just go out and fix it yourself, it's gonna be hard to go back later, and recoup that money if it's not easily if you're not able to show it because it was cash, because it was a cousin, whatever the circumstance might be.
Agreed.
Why does my insurance policy seem clear until I try to use it?
Um, but so it's kind of a funny question because I'm not sure people's insurance policies actually seem very clear. I think what I'm going to interpret what that question means, which is people think they have insurance and things are just going to be covered. But whether or not they've studied and read their policy, and I will include lawyers in this because we have represented tons of lawyers who don't understand the policies they purchased. Many do, but many don't, and many haven't read them. And so, you know, even I think they don't realize it's clear. They just think they got the coverage they were supposed to get. That doesn't mean they understand their rights and obligations under the policy. So anything seems clear when you think you're going to get coverage. And if you get coverage, then it must have been clear. But if the coverage gets disputed or investigated, then you're like, well, I thought it was covered. And so I'm not sure that they seem clear. I think people have a version in their mind of what the insurance policies are going to do for them that doesn't always necessarily turn out to be the case.
That's fair. Business insurance and homeowners and auto, all of these, you know, trying to read an insurance policy is a pretty daunting task for most people, even lawyers that don't necessarily practice in that area. Maybe even lawyers that do practice in that area. You're talking about hundreds of, small print pages, but uh I don't know the best way for people to go about figuring out what's covered and not covered without there being a claim. People typically don't wake up one day and say, I'm just going to read all my insurance policies out of curiosity. And it's probably like, this might not come out the right way, but every 10 years or so, I say, I'm going to read the Bible. And I never get past like the third page. I'm like, Paul was the second cousin of Amos. I'm like, I'm done here. And, the second page of my auto insurance policy, I didn't get past like the second paragraph. I'm like, So, there are people, who probably can explain to you generally what's covered. There are, with any kind of policy, there are covered claims, there are things that result in coverage, and then there are exceptions to those things where even if it's covered, there's still no coverage for one of many, different kinds of reasons. But, listen, a deck page is a good place to start. Talking to your broker is a good place to start.
Right.
But, realistically, most people, whether you think you have coverage or don't have coverage, when someone sues you, when something happens, you have a flood, you have a fire, you have a lawsuit, you know, maybe there's coverage, maybe there's not. You tend to learn from bad things. And so, and we do a lot of work with labor law and with construction companies where they get brought into a sort of third-party suit, and there's, action over coverage has been a big issue the last couple of years, and, and the construction company says, "Well, I got this insurance. I don't understand why they don't cover. I got sued. I have the insurance. Why am I not covered?" And there's all kinds of reasons that are probably beyond the scope of this question. But, at the end of the day, those people end up going back to their brokers saying, "Look, we need this coverage, we need that coverage," and maybe a good broker can steer you through that stuff. But at the end of the day, to get back to the original question, insurance covers what the insurance company sort of carves out what's covered, and as much as you can buy different types of supplemental coverage, or you can't really negotiate at some level, the terms of an actual policy. You can buy different types of coverages, but, the language that's in a particular policy written by a certain carrier, you can't call up their general counsel being, "Listen, I want to change the language of the policy." That's probably not realistic.
Right. That's a whole nother level. But insurance policies are complicated. Being insurance recovery lawyers, we're trained to understand how they're structured and what, you know, how and they're all set up in a particular way. But they're not fun to read. They're not easy to read. And also, trying to read them just to read them and understand everything that's covered and not covered, you need a good broker. And secondly, when there's a problem, a lot of what's in the policy doesn't even matter. It's specific provisions that you're looking at, specific provisions of the insuring agreement, specific provisions of the exclusions, specific provisions of the conditions, specific endorsements or riders. So, trying to read the entire policy in the context of a claim, it doesn't even matter. It really matters of how that particular set of facts lines up or doesn't line up with coverage, right? So, the short answer is they're not really clear and easy to understand, but having the right professionals, which means a good broker, and then when needed, a good coverage lawyer, is what's the essence of understanding it is. And I would start as a business person or a homeowner, anyone, with a good broker.
Can a business actually ignore a legal letter and hope it goes away?
The short answer is yes, they can, but depending on what the letter is, there may be obligations for you to respond, and failure to respond may result in things that you don't like. For example, if you get a 30-day notice to quit and you have to vacate a premises, you may be prejudicing yourself and not responding to it. You may have rights and defenses that you could raise in opposition to that. You may be obligated to take that letter and find some money and pay rent, or to call them and negotiate a deal. I mean, there's a lot of typically when you get a legal letter, somebody is asking for something from you. Not responding to it, it's conceivable that that person could say, "Well, they didn't respond to me, I'll just go away." My experience, that's usually not what happens. But let me give you an example where it's really detrimental. There are states that have deceptive acts and practices statutes. Massachusetts is one of them, and the statute is called Chapter 93A. If you send a Chapter 93A letter, it triggers obligations to respond with a good faith position statement or offer. If you fail to do that, it creates certain rights to the sender of the first letter, like treble damages, attorney's fees, even if ultimately the claims are not what, exactly were asserted in the first letter. The person receiving that letter, by simply ignoring it, is exposing themselves to treble damages and attorney's fees, which, as we know, can be a tremendous amount of money for a case that might not necessarily have been that great a case to begin with. So the general advice has to be, when you get a legal letter, read it, take it seriously, consult with counsel, and do something. Burying your head in the sand in response to things that you don't like is generally not a great way to go about living your life, although a lot of people do, some with some measure of success, but from a legal standpoint, probably not great strategy.
I agree, and I will say there are so many instances in our practice over the years where we are involved in trying to extricate someone from something that they chose to ignore. Um, there's just one example after another, and Matt gave a couple of great examples there, but I am still, after 35 years of doing this, getting clients and representing clients who didn't respond to some type of legal notice, legal letter, lawsuit, and we're constantly extricating people from those. So, kind of like the question about, what's the one thing a business owner should do is talk to a lawyer. Well, same thing. If you get a legal letter, don't ignore it. And if you're not sure what it means, send it to your lawyer and just say, do I need to do anything with this? It's not It's not a hard thing to do. Delegate it to someone in your company to do, even if you're super busy. Find a strategy or a structure or a way. And now we were talking about AI, take the letter and stick it in AI and say, what is this and what should I do with it? At least do something.
So my favorite sort of quasi-legal example would be anyone who has kids with a car in Metro New York, without an easy pass that you pay for, invariably that kid goes through, you know, the New York State Thruway and gets a 78 cents toll charge, ignores it, or goes over the bridge for a $6.75 toll, and then they ignore that, and 3 months later, they come to you with a letter that says, "I owe the Triborough Bridge and Tunnel Authority $579 because every $6 charge became a $317 charge because they tacked on these fees."
Yep.
Good luck solving that. So I
Right.
think most people can probably relate to that, but,
That's a good one.
you have, whatever, 10 or 20 days to pay the fine, to pay the toll, otherwise it goes up, 250,000%.
And that's aggravating and annoying things, but in your business, those things can be game changers. They can, you wind up stuck with us hiring lawyers, paying lawyers, trying to extricate, wasting your time. Those one of those things about, if you get a lawyer early, you prevent something horrible later. This is the same thing. Letters come in, do something with them to make sure you're protected.
What's one thing every business owner should have but often doesn't?
The simple answer to that question is a lawyer. Um, because you need to know whether you need something and what it is you need, right? So you need to talk to a lawyer. Like, do I need to form a company? What kind of company do I need to form if I need to form a company? Do I need insurance? What kind of insurance do I need? Do I need any kind of a contract to do this? Is there some law or regulation that I have to worry about before I start doing this business? Those are things that a lawyer can answer. So a consultation with a sophisticated lawyer that understands and can ask you questions about what you're doing with your business, that's what you need.
Yeah, and, there's a lot of, AI out there where you can find employment agreements, shareholder agreements, operating agreements, and those are great. Those are great resources, but lawyers that have been in this space for years and years and years have seen all of the different sort of issues that come up between partners with solo businesses, whether you're getting sued by landlords or employees or competitors or former employees or whatever it is. AI can't necessarily look at what your plans are, what your business model is, how you're set up and structured to give you advice based on what it knows. AI is giving back to you information that you're feeding it, through whatever sort of platforms it's searching on. But a good business lawyer who's done this for years and years and years, they know in advance the questions to ask you, and they give you advice on how you set it up. Is it an LLC? Is it an Inc? Is it a corp? Is it in Delaware? Is it in New York? Right? They know if you have two partners, if you're going to have a third partner. Do you need shareholder agreements? Do you need operating agreements? These are all things that a good lawyer gives you. One thing I'll add to that is no matter what size your business is, talking to a good business insurance broker is also important because eh, saying I'm starting out small, I just have this little shop, I don't need any insurance, I have 2 employees, I have 3 employees, you know, you need there's all kinds of coverages available to businesses, whether people come onto your space and fall and get injured, or whether or not your products are being delivered and there's a car accident with the people delivering. There's all kinds of insurance issues that come up. And a business lawyer can also help you find those people and give you some recommendations on that issue as well.
Right. And I'll just add, you could not realize that there is a rule, a law, a regulation, or something where you spend all this money, you set up your business, and then it gets shut down because you didn't know that you had to comply with uh, some rule, some licensing requirements, some certificate requirements, something that you didn't know you needed because you just didn't know. And you don't want that to, put a knife into your business just when you're getting it up and running. So, understanding what you need to do to make sure you can open and operate this business and be protected is the essence of what a lawyer can do for you. Great.
What's a legal myth people believe that's totally wrong?
Well, from my experience as an insurance recovery lawyer for all these years, um, the belief of individuals or business owners that if an insurance company is not paying their claim or is disputing the value of their claim, that they're going to be able to get bad faith damages, that they're going to be able to get emotional distress damages, that they're going to be able to get attorney's fees. And there's a belief, and there's a lot of stuff out there online that, in the context of what we'll call bad faith, they can get all these remedies beyond what they're entitled to under the insurance contract. And the vast majority of that is not true. Um, if you're going to have a bad faith remedy against an insurance contract, an insurance company for denying your claim, it's going to require some really bad conduct, and you're going to have to fight really hard to get it. And it's going to depend on the state that you're in. And so, assuming that you're going to get all these extra remedies when a client calls up and says, "Well, isn't that bad faith?" Um, I would suggest to the consuming public that most of the time it's not, and most of the time they're not going to get it. That would be the biggest myth in the insurance world.
Nice. So in the criminal context, I think a big myth is that the police have to read you your Miranda rights before they arrest you. And that's not true at all. You have to have Miranda rights read to you before they interrogate you. And that requires both that you're in custody and that it's a custodial interrogation. So there's no requirement that they read you your rights. You have the right to remain silent. You have the right to a lawyer. Before you're arrested, it's only before you're interrogated. And the second thing that sort of goes along with that is that the police have an obligation to be truthful with you during an interrogation. That, again, there's some push in some states to legislate against that. But for the most part, there's no obligation for the police to be truthful with you about the communication that they're giving you, whether or not they have other witnesses, whether or not there's certain evidence at the scene, whether or not, there were witnesses. Police frequently use some form of deception in order to get people to confess or admit to certain components of crimes.
So basically, what you're saying is the police can lie to you to induce you to say things that are against your interest.
They can, but again, there are certain states, Massachusetts being one of them, that have tried to take some steps to limit that. But for the most part, that's something that the police can do.
Good to know when you're thinking about the fact that you don't have to answer police questions when you're in custody if you don't want to.
Yeah, there's actually a third myth that sort of follows that. That's that if you invoke your Fifth Amendment privilege or you choose not to communicate with the police or prosecutors, that means that you're guilty or it makes you more likely to be convicted, and that is a gigantic myth. There's times when you can help yourself in terms of not being charged if you're communicating information that helps to lead an investigation away from you. But again, that's something that should be done with the advice and guidance of counsel. But the fact that you're not creating new evidence that can be used against you, that in no way increases the likelihood of you being indicted or convicted.
So the old statement that people get themselves in trouble when they have very limited rights under the law when they've been arrested or they're in custody, which is, I have nothing to hide. Um, they can get themselves in trouble. And you have really powerful rights, but they're very limited rights. You have the right against self-incrimination, and you have the right to an attorney. Those are your two biggest rights you have when you get in trouble criminally. And if you're not exercising them, we would suggest that you're probably making a mistake.
Hold on to those rights.
Is signing something online really the same as signing with a pen?
Mr. Conroy.
Mr. Schwartz. So the short answer is sometimes. There are states that have specific statutes or regulations about the use of electronic signatures for certain types of documents, contracts, real estate transactions. Florida, for example, and California have an extensive sort of regulatory setup, including the software that you have to use, the platforms that get used in the types of agencies, either title agencies or real estate people, that basically have access to these things to make sure that the signatures are legitimate and that the identification procedure is followed. But typically, e-sign documents, to the extent that you're signing credit card applications or leases online or sublets, those things typically go state by state. But I think every month that goes by, you see more and more of that coming online, so to speak.
Yeah, I would say the vast majority of things that you sign online now can be valid and enforceable. But there are certain things that require notaries. There are certain things like wills where you've got to look at certain state laws and state requirements. There was a period of time during COVID where there were electronic signatures for almost everything and virtual notaries and all things. But some of that has now been revoked by certain states. So you have to, depending on what it is, you would have to know specifically whether there are rules around it, the way Matt's describing. But if you're signing something electronically, you have to assume when you're doing it that you're going to be bound by your signature.
And if you're the one looking to enforce an agreement, you should probably at least seek counsel if it's a big enough deal where there's question about whether or not you need a live ink signature or a notarized signature versus some kind of an online signature.
Agreed. So especially if it's notarized or if it relates to like a will, those are things where if you're looking to enforce it or for it to be enforceable, you may want to check with an attorney.
Hmm. I'm not sure. I don't believe in New York an electronic signature is sufficient for a will, but I do think it's sufficient for a lease or a contract for sale. I'm not sure that you can do it for a deed yet, but I think it's moving in that direction.
Yep.
Can I really get sued for anything?
I'll take that.
Mr. Schwartz?
Yeah. Well, in the American system, you can't really stop someone from bringing a lawsuit. So if they want to file a document and sue you and you have no connections to them, you never heard of them, they can put it into a courthouse and file an action against you. But, you know, that's not going anywhere and it's not going to go anywhere fast. So if you're going to file a lawsuit against someone, a civil lawsuit, you need to have at least some reason. Otherwise, you're spinning your wheels. You're going to waste your time. Your claim is going to get dismissed, and you may get yourself sanctioned in terms of some money damages or some other remedy that affects you. So, yes, theoretically, can you bring a lawsuit against me even though you never met me, you had no connection to me, and there's no reason for you to sue me? No one's going to stop you from writing something up that's frivolous and false and sticking in the courthouse, but there will be consequences for doing it.
Yeah, but we live in a litigious society, and part of our freedoms include the freedom to sue people, the freedom to seek redress from courts, and there are, I don't know about countless, but many countries across the globe that people don't have those freedoms. So, can somebody sue anybody for anything? People are free to bring lawsuits. Whether or not the cases have merit is a totally different question. But there are, as you mentioned, obligations to, um, to bring non-frivolous claims, and there are certain jurisdictions, federal courts, for example, where people can be deemed to be um, like serial litigants, and courts will take notice of people who are sort of perpetual plaintiffs, and where people are bringing repetitive claims against the same person or different groups of people. At some point, courts can take action, either sanctioning people or barring them from filing lawsuits in the absence of seeking permission from the court to do it first. That's pretty rare, and that would be the exception for someone who's sort of abused the right that we have as Americans to seek redress.
Yeah, and so the idea is we have access to justice in this country, and I would say that's great. I'm glad we have it, and anything that gives you unfettered rights, like unfettered access to the justice system, is going to mean that there's going to be abuse at times. But I think the balance for Americans is that we have the access.
Agreed.
What's the biggest insurance mistake business owners make before a loss ever happens?
I'll take that. So there are a couple things that I've experienced in my 35 years of doing this that I think are mistakes that businesses or individuals make. Um, the first thing is to recognize that you have a claim and to tell your insurance company about it. So notice of claim, notice of circumstances that could lead to a claim, knowing that you need to do that that's a condition of coverage under policies, and especially under claims made policies where if you don't give them notice during the 1-year policy period or an extended period, your claim is gone. So notice and notifying of a claim or a potential claim is one of the things I see consistently as a problem. The next one is understanding that you're going to need, if you have a claim or a potential claim, let's say it's a first party claim, that you have some documentation of your loss. And we've talked about this in answer to another question, getting public adjusters, making sure you having your records of what happened and being able to document to the insurance company the amount of money that you're entitled to because you had a loss. If you can't do that, you're not going to get paid. So those are two examples of just simple things. Proof of your damages and notice, right? And the other thing is just realizing that you might have coverage. There should be somebody in your organization, if it's you or somebody else, to think about, hey, we have these towers of insurance for all these different things, for this type of loss, for that type of loss. Is this thing that just came up, could this be covered? Maybe we can get reimbursed for this. A lot of people and that's where they get the notice problem too. They never knew that they could have coverage for this. You paid all this money in premiums, you bought all this coverage, and then when something comes up that could be covered, you don't tell anyone about it. So those are more than one thing, but those are three things I see coming up consistently that are simple things that you can do to protect yourself.
Yeah, and this is along the same lines, but understanding what your coverage is and isn't. And I think a lot of business people just don't think about insurance. They think, well, I need some insurance. They go out and they get an office pack from Travelers through some business broker that they've never met before. They have no idea what they have or don't have. And, you get all kinds of issues depending on the size of your business, whether or not, whether you're going to get employment related coverage, right? Those are things available to you depending on the size of your office, what you do, who works there. Those types of coverages can be really important. If you don't think about it, by the time a claim comes, now you're sort of backing into it, calling someone that you've probably never met before, saying, am I covered? Or trying to read your policy and figuring out, is this covered? But, any business, you should look at what coverages do I have? What does it cover? What doesn't it cover? Are there things that I can do to make sure that, without sort of blowing the budget on premiums, that I'm basically safe in my normal operations, and that there are things that happen in the course of operating a business that result in claims, whether they're employment claims, product liability claims, personal injury claims on your property, fire and flood damage to your business, or your business inventory. Those are all things that, insurance can cover. But, what do you have? What do you have for policy limits? What do you have for deductibles? These are all things that people should be, familiar with. And, sometimes the mistake comes before a claim is ever filed because you've got insufficient coverages, or your deductibles are too high, or you're just not getting a good deal with the carrier that you're with.
Agreed. And a broker can be a good person to summarize what is generally covered under your policies. And someone in your company should know what that is and be aware of it, so that when something comes up, someone can go, hey, I got the summary from the broker that says these things could be covered. And, it really doesn't harm you to notify an insurance company of a claim, even if it turns out that it's not covered. Because if it's not covered, they didn't pay any money in legal fees to defend you. They didn't pay anything on the loss. So it doesn't create loss history. That doesn't mean you willy-nilly throw everything to the insurance company every time something happens. But to err on the side of, hey, maybe I should just notify the insurance company, or tell the brokers to notify the insurance company. To think along those lines, you're better off. And I'll tell a quick story. In my early years as a coverage lawyer, when I was defending insurance companies, there was this wonderful law called the Environmental Superfund Law that was passed in around 1980 in response to Love Canal, where now federal and state governments were going and knocking on the doors of every polluter in the country, or everybody who ever sent anything to a landfill, and saying, guess what, buddies? You need to pay to investigate this, and you need to pay to clean it up. And some smart lawyers started to think, hey, I wonder if this might be covered under our policies. And that turned into a 20-year war with insurance companies, with billions of dollars paid to corporations for the cleanups for these environmental claims, that just by somebody saying, hey, this could be covered by my insurance, turned into a national war with insurance companies. But it resulted, again, in billions of dollars being paid to corporations to reimburse them for the cost of investigating and cleaning up environmental contamination.
Thank you for joining us. Hope to see you on the next one, which will be coming very soon. And just a reminder on the disclaimer one more time. The information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. Watching this podcast does not establish an attorney-client relationship with any of the attorneys featured. Take care, everybody.